So you've been asked to give a deposition. I'm David Charlip, and I'd like to help you by discussing what to expect and how to prepare for giving your deposition. The first thing you have to understand that a deposition is not like the two of us chatting. It's a formal proceeding whereby you're asked questions, you give answers, and a court reporter will record all of those answers. So it's very important that you keep in mind why you're there and what your purpose is. In giving a deposition, your purpose is not to tell stories. Your purpose is not to get chatty about what happened. Your purpose is basically one thing and one thing only: answer the questions that are asked of you. Now, why is that? The reason for that is a deposition doesn't help you. It locks you into your testimony. It provides a written record that the opponent can use to come back and challenge you with things that you may testify to in court. And so for that reason, it's important that you keep your testimony short, to the point, and responsive to the things asked of you. Now, when you give a deposition, you have to understand the types of questions that you'll be asked. There are two types of questions, and we're going to talk a lot more about that later. But essentially, one type is open-ended questions. The other type are closed-ended questions, sometimes called leading questions. And we're going to talk about the different ways that you would approach both of those types of questions. But before we get into that, let's talk about the procedural aspects of a deposition. As I indicated before, you're going to be placed under oath. That would be the same oath that you take in court were you to testify in court. A court reporter will be present, and the court reporter will be taking down everything that's said. That's very significant because the court reporter can't take down two people talking at once. And so that's one of the key things you have to remember. When you're giving your testimony, you have to listen to the question. Don't cut off the reporter, the questioner, as sometimes we do when we're having a conversation. Wait till the question is finished. Don't start to answer until the question is finished. The reason for that is threefold. First, if you answer the question before it's finished, you may not be answering the right question. Second, as I indicated before, the court reporter can't take down two people talking, so while you're answering and the questioner is still questioning you, the reporter's in a bind. And third, you want to let some dead air exist between the end of the question and the beginning of your answer. Why do you do that? Number one, so I can make an objection if necessary. Number two, so you can say to yourself in your mind, what am I being asked and how am I going to answer it? It's called thinking. Most people talk without thinking. In a deposition, that's not a good thing. You want to think, compose your answer, and then give it. In doing that, what you want to do is focus on the question that's asked. If the question starts out with who, you want to give a person's name. If the question starts out with where, you want to give a place, and so on. So you want to focus on what's being asked of you. Second, you want to analyze whether you're being asked an open-ended question, where you have to give a bunch of information, or a closed-ended question, where a simple yes or no, or a date or a place or a person may suffice in answering it. If you're asked a closed-ended question, don't be going on about all kinds of things or telling a story in answer to the question. Just say yes or no, or give the specific information that's asked of you. If you're asked an open-ended question, then you need to go through in your thought processes and decide how are you going to answer that question. And try to keep your answer short and to the point, being responsive to the question that you're being asked. So, we talked a little bit so far about open and closed-ended questions. Closed-ended questions, as I said, are often leading or questions asking for specific pieces of information. You want to be very short and to the point with those questions. 90% of the time you're going to say yes, no, I don't know, or I don't remember. Open-ended questions I like to call the money questions. They're the questions where you tell what happened in your case, how you were damaged, how you were injured, what the specific chain of events that caused your injury or damage were. And so with those questions, you need to carefully go through the facts of your case and compose your answers before the deposition is taken. Be thinking about what you do know and what you don't know. And that raises an important issue that we need to discuss in further detail. One of the key things in a deposition that you will always do and that you must do is, of course, to tell the truth. Now, telling the truth sounds like it's a simple thing, and most people would say, well, of course I'm going to tell the truth. It's not my intention to go into a deposition and lie. I know what happened, and I'm going to tell exactly what happened, and this is my chance to do so. Well, first of all, it's not as simple, because most people, when they're deposed, are deposed sometime long after the events at issue. Recollections fade. It's not something you think about all the time very often, and so the facts and circumstances may not be fresh in your mind. Second, many people's recollections are colored by their experience and perceptions, and so there's aspects of what you experienced that may be clear, but there are other aspects that may not be so clear. There may be questions that you'll be asked that you never asked yourself and that you never thought about the answers to. And when you're asked those questions in deposition, and when you feel like the facts are hidden,